Okay, so this is it's probably going to be over the course of either one or two videos. I'm going to look at the multiple sources of law, and then we're going to move down to law officers and the social work function, and how intersectionality is currently embedded in UK law. So I'm going to start by explaining how law is viewed at an elite level, because the simple fact is that they don't. I don't know what to tell you. So the very, very first lecture at the LSE Inequality Institute, and I think I talked about it in that playlist, Crisis in a Mediating Class, was a lecture about Rawls, who's a philosopher at the core of neoliberal economics. And Rawls basically is a very, very turgid to read, full of shit philosopher, and they use it like shed symbolism, so they just go, it's a Rawlsian motif, and that means it's fair. And every discipline at the LSE is aware of Rawls, and every discipline bounces against that. The second lecture was about law, and it became very, very apparent very, very quickly that in terms of understanding of how the law shapes policy and our systems, it goes as far as, well, we know that equality legislation exists. Now, I did have, my second lecture was a law lecture with a very, very interesting academic called Nicola Lacey, who was very, very interesting. And she's a feminist academic. And she was writing intersectional critiques of UK discrimination law in like 1985, so. But outside this was seen as isolated in a silo in the Gender Institute. This was not at all related to policymakers. There is no policymaker that's going to the LSE that's coming out with an understanding of the rule of law. And I know this because when I started to discuss the law that I'm about to discuss with you, it was just like either like that or completely defensive, or that's not in the literature. And you're like, well, that's not the fucking literature, but it's the fucking law. So law has multiple sources. Now, the primary source of law in this country is our lawmakers, and that's our MPs at Parliament. Legislation is constructed in Parliament. That's what they're for. They come up with laws and then, they are enacted. But that is not the only source of law that we have. So what I've done is I have written some notes, and I never do that with these videos, so you're just going to have to bear with me if I get really jumpy. So basically, outside this, you've got legislation that's imposed by Parliament. You've also got common law and precedent. And what precedent is, it's the understanding that a judgment made in a higher court becomes binding in lower courts. So what this means in practice for everybody who works with this is that a judgment can be made in a high court on Tuesday, and the proceedings that you were going to go to a lower court in Leeds on the Friday may not happen, because that judgment might have completely undermined your case. And there's no point, like, that might end your proceedings. I mean, really, it's that, huge. And there is also sources of case law. Case law builds up, precedent builds up, and this is what happens. And another source of case law is the judicial review process, which is worth a Google. And that's where people can actually apply to challenge decisions and laws, and they can actually mount their own challenge and have it heard in the High Court, and that's worth a look. That's actually worth looking, and that's actually the source of a lot of case law, which then impacts other sources of law. So the court structure, it's really, really important to understand court structure, because we've just applied market-based rationale to it, and we've stripped the primary output of it in an effort to make them self-financing. Now, we have a very complex court system in this country with many, many divisions that I'm not familiar with, by the way. I'm largely concerned usually with, the family courts. That's my interest. But there are many, many divisions of the courts. There are many different tiers of courts. There are, with the highest courts being at the House of Lords, and and then, your local magistrates court, your local crown court. And there are different burdens of proof. So civil courts have on the balance of probability, which is the preponderance of evidence suggests. And then there is beyond reasonable doubt, which is a criminal standard of proof. And we have to manage a half space between that. So child protection cannot be done to a criminal standard of proof. We do it to a civil standard of proof. Did this happen? the preponderance of evidence suggests that it did, which means that we're working on a probability that actually we could be very, very wrong, and we're exercising a lot of power. And so we have to be aware, and we have to have people who are aware of these tensions. Now, in addition to that, you have the shifting sands within institutions. So, like, working at the DWP was like standing on shifting sands. I mean, it's called the Decision Maker's Book. The sanctions thing, that's actually linked into the Courts and Tribunal Service. Yeah. There's a fucking mess of a travesty of justice that's occurring at the moment, which the judiciary are actually outraged about, because they know that they should not have the Courts and Tribunal Service used for this. But decision making, it used to be, they've kind of glossed it, it's really been eroded in the last kind of decade, but it used to be called Secretary of State decisions. You were referring to a Secretary of State for a decision. Now they're just called decision makers, and you can look at the decision makers, and these evolve all the time. Now, often you're never covered by like one law. So we have a bed of human rights law, which, you know, discrete law should be compatible with, and decisions are made. If you read court judgments, you'll find that they assess whether or not, you know, judgments are made, assessed against human rights as a framework. But also, you know, we have lots of overlapping legal frameworks. We have, you know, tensions between legal frameworks. We have law has limitations, you know, so often, you know, I'm trying to think of an example. Adult social care. Limitations of law and social care are that we have not yet properly developed the facility to consider things like adult risk and, you know, a whole bunch of issues around vulnerable adults. And we're realising that we have to do this, and, you know, instead we've had community care law. Now, what I'm going to do, I'm going to post under this, just out of interest, I'm going to post the list of legal frameworks that you would have to consider in children's law for all your decision making, and it's about this long. And, you know, everything that we do is covered by law and shaped by law, and this law is constantly changing from multiple sources, because this is our rights. This is our democracy. This is like the baseline rule of law in a mature democracy. We have these massively complicated evolving systems, but that are actually very, very sophisticated. They actually have roots that are thousands of years old. And, you know, we have, you know, I think one common criticism of our judiciary is that it's pale, male and stale, and it is. It very much is. But what's also true is that our independent judiciary are our front line in the defence of our democracy. And actually watching judges at work sometimes is a fucking dream. You know, I've had proceedings that I've been involved in where we've known fine well that we should not be going to proceedings. But we've had a senior care manager that's made us. And then you get to court, and the judge just looks at it and goes, no, go home. This is not a case. You know, our judiciary are just actually fucking excellent in this country. And so this is what shapes, and we have to have court officers. Within the courtrooms themselves, we have a variety of tensions. We have court officers, we have legal counsel, we have judges, we have clerks, we have magistrates, we have literally all these people have a function, and it's very much worth going down to your local magistrates' courts and watching them function for the day, because it's like watching a ballet with defendants just plopped in as replaceable pieces, like it really is. But it's actually very, very worthwhile sitting down at a court, Crown Court or Mags, for the day, just to watch and to understand how our system functions. And it's actually very, very much worth doing this. And this is a very complex system. And the function that I'm trying to fulfill is the one, you know, that's within courtrooms to assess how different competing frameworks are impacting someone, their social context and the power dynamics that they're actually in. And understanding which legal frameworks are joined around which vulnerable people, so that you know. And so, to me, this is second nature. I'm used to keeping an eye on the baseline rule of law and how it's evolving in the areas that I'm interested in. And what I was really shocked to find out at the LSE is that this is an alien concept. We do not have policymakers who understand this, because our elite universities do not understand this. Because what they have is in a legacy identity where they decide who's deserving. And so they're not aware of this rule of law, and in fact they get very, very offended when you say that a law that maybe emerged as a response to a vulnerable person mounting a legal challenge might actually take precedence over an academic discipline in an elite institution. And particularly welfare economics. There's absolutely, you know, at the LSE, they do not understand why welfare economics, which seeks to prevent women from leaving the family unit, is not acceptable in a country where women are legally obliged to leave the family unit if there is abuse. And they are offended by the notion that those women's rights take precedence over their legacy identity. It's about as simple as that, really. And so what we have at the minute is a massively complex, mature legal system. And what's happened is that we have applied market rationale to that legal system. And it's done exactly the same as it's done with all these other institutions. It's stripped back their primary output, and our justice system is collapsing. To put it bluntly, it's actually fucking... And if you have a look at some of the kind of debates around solicitors and barristers at the moment, you'll find that our justice system is in deep trouble. And that's going to get bigger, because you can't actually abdicate the rule of law. And all it's done is it's shown up the institutions like the Guardian and the Labour Party and our trade unions, who felt that their legacy left-wing identity would replace this rule of law, and now they're screaming turf at anybody discussing it. And, you know, this is really deep-rooted. You know, the next video I'm going to look at court functions, and I'm going to look at the social work function in specifically.